Good afternoon, all. This is Deepa Mulchandani. I would like to welcome once again. And this session is going to start now, so I will request all of you to be seated here. I will request Mr. Sunit Shah to escort our faculties to the dais. Mr. Satish Gupta as a moderator to this session. We will welcome Mr. Sanjeev Bhatt as a panelist to the session. We welcome Ms. Pooja Mahajan, and we would like to welcome Ms. Maya Gupta. If I give brief introduction to all the panelists and the moderator, I would like to introduce Mr. Satish Gupta, who was the resolution professional at the very well-known case of SR Steel. We welcome Ms. Sir here. I would like to introduce Mr. Sanjeev Pandey, retired as a DGM of NCLT policy of Stressed Asset Resolution Group of SBI in May 2022. He is currently associated with Messrs. DSK Legal Mumbai, and he is also working as an advisory with RBI Mumbai. I would like to welcome Ms. Maya Gupta, who is esteemed insolvency professional since her registration with IBBI, he has successfully resolved numerous insolvency companies having debt of more than 5,000 crores over last 6 years. I would like to welcome Ms. Pooja Mahajan, who is managing partner at Chandoik and Mahajan company, and she heads the restructuring and insolvency practice of the firm. Ms. Pooja is part of Executive Committee of Insol India and a director on the board of WIRC. I welcome all the guests over here. Let's begin the session. I would request Secretary Sir of ICAI Ahmedabad to felicitate the panelists. And I would request to felicitate Ms. Maya Gupta ji. And now, Satish Gupta ji. Thank you so much, sir, for coming here. And Mr. Sanjeev Pandey ji. Now I will request the esteemed panelists and moderators to start the session without wasting much of the time.
Good afternoon. Good afternoon, everyone. This is the afternoon session, and we'll try to make it as interesting as possible. And topic itself is fast emerging and evolving as a area and which is very important for the recovery and the realization for the various stakeholders, and also to achieve the overall objective, wherein the company which has gone into liquidation, essentially to achieve that liquidation process is completed expeditiously. So as per the IBBI quarterly newsletter for the quarter ended December 2023, There are 1,546 liquidations which are currently ongoing, and out of which 55% are going on for greater than 2 years. In 830 cases, final report has been submitted. However, in 1,546 cases which are going on for a number of years, some of these cases are going on for last 4 years or 5 years. Okay. So in November 2020, IBBI had come out with a new regulation after circulating a discussion paper on non-readily realizable asset. So essentially, to see how after the liquidator has sold the various tangible, intangible assets on which can be sold easily, and the company is or the corporate debtor is left with certain assets, illiquid assets for which there is no ready buyer, okay, and how to address those assets. So those assets are called non-readily realizable assets, and Regulation 37A was introduced. So we see how there has been progress in realization of these NRRA, we call it, and what is NRRA and what kind of assets are included in this, and at what stage this is evaluated. I will ask, I will request Maya to elaborate on that. She has been handling many liquidation cases and which have reached this stage, and how you essentially, at what stage you decided, you along with the stakeholder consultation committee, that now it is the stage where NRIs should be identified and the future course of action. So that is the a real a decision to be taken by liquidator at this point. So I will request Maya to.
Thank you, Satish ji. First of all, I would like to thank you all the participants and the organizers to provide me an opportunity to share my thoughts and the experience on the NRRA. So after the COVID, there was a slowdown in the economy, and there was various cases wherein the NCLT itself is taking soft corners for these assets. So when these Regulation 37A was introduced in the regulation, so in my liquidation matter, since in the liquidation, the matters which doesn't have any backup assets and the money for realizing, for that the law has eventually evaluated this amendment, and in my 3 matters that was undergoing liquidation, I applied this Regulation 37A, wherein as per the regulation, there has been assets which cannot be sold easily are termed as NRRA, which includes the contingent assets as well, other than those assets which cannot fetch any market value. So in one of my matter, Ritu Tandon versus Rain Automotive India Private Limited, there are basically no assets as of date when this order of liquidation was passed. So there was only the applications that as a liquidator I filed for recovery based on the available information with me. So I categorize those applications into 3 parts. 2 applications were part of Section 60 subsection 5, wherein I had the certainty that I will get 100% out of these applications, and some set of assets which pertains to the avoidance applications, that is referred under regulation section 43 to 51 and 66. That is the other set of applications that I sold as an NRRA. So there was 2 sets of applications. So in first 2 applications, the court has very well adjudicated, but due to the nature of that our jurisdiction, that the person is having authority to go to the appellate tribunal against the order passed by the adjudicating authority. So those matters are pending before the appellate tribunal. So we are not going to that. But for the another set of assets which pertains to the avoidance transaction, the court said that that it is an unjust enrichment, first of all, that you have huge set of assets sold for a peanut amount. Second, that court didn't consider that the assets which have been transferred, assigned as an NRRA doesn't have any value, because valuer doesn't provide any value to the contingent assets. So that cannot also be a part of a liquidation estate. So in that matter, the court rejects the assignment deed itself when assignee filed an application for implement of those avoidance transaction application. So there has been different perspective that the adjudicating authorities are taking in respect to the NRRA. So wherein in Ritu Tandon matter, I took the option 1 as prescribed in the circular paper, discussion paper published by the IBBI, that you can assign the avoidance transaction or the NRRA through two options. One is an absolute assignment, and second through compensate facility. So in Ritu Tandon matter, since nothing was there and I didn't have any hope that these avoidance transaction would fetch something, because the parties are such which are not traceable, and these applications were filed based only on the transaction audit, and those transaction audit report itself was prepared based on the bank statement and the data that was available in the public domain. So that all are aware that the court has given a landmark judgment saying that contingent assets cannot be assigned until it is adjudicated. But in my other matters, which I assigned through option 2, that is compensate facility, that was allowed by the Honorable Adjudicating Authority in both the matters. And in one of the matter, in recent April 2024, in April 24, the same bench 2 has allowed the assignee to implead as an assignee in those transactions which was assigned as an NRRA.
Thanks for elaborating on NRRA and how, what challenges you have faced in getting the approvals for this assignment of NRRA. Can you briefly also describe, I will request Mr. Pandey, that, liquidation estate will constitute multiple assets. So after tangible or intangible assets are sold, what kind of assets which are left, and the liquidator is has to find a solution before the company can be dissolved. That is a challenge which many liquidators are facing, because first of all, there is hardly any funds available or being made available to the liquidator by the stakeholders. And as time passes, cost also increases, litigation costs, or whether this managing, and the cases also not get closed. So the bandwidth of the liquidator and stakeholder committee is also blocked. So I would request Mr. Sanjeev Pandey to give his perspective on this liquidation from the stakeholder committee perspective, that how to essentially, this concept will help to the IBC ecosystem.
Thank you. Thank you. So basically, we are struggling with the question here, under liquidation, when all the physical assets and tangible assets are sold, so RP is left with certain assets which have no certainty of realization, and no certainty of valuation also. But without disposing them, he cannot just file form H or close the liquidation, go for dissolution. So there are, depending on the different type of businesses, there can be different kind of asset. I have identified 5-6 different categories. One is, of course, as Madam said, preferential transactions, which looks very obvious. But then again, the case laws are not yet very clear ki how, at what stage you can sell them. That's what I think your version is. But they have a value. So what I think the judgment said is that you get it valued first, or let the court decide a value on that. I do not really concur with that view, because these assets, unless they are realized, nobody will know the real value. You can put a value of, say, preferential transaction of, say, 500 crore rupees on a person, ki, okay, this is recoverable. But that cannot be the value of that transaction. Value will rely on what actually the net worth or the assets of the payee who has to make that payment. So that is the difference between the court's understanding of the value and what the market understands. Market will look at the real assets, underlying assets, which may be the assets belong to the promoters who have to pay this liability. Similarly, there are other litigation rights with the company. There are unrealized debtors. Most of the companies have big list of unrealized debtors, which are purely going waste. There is no recovery as such. Neither, I think, RPs are making effort to make a recovery. Major deficiency is the lack of information. One thing I always said in IBC, biggest deficiency has been the information. Most of our cases or the companies have lost value because the RP never got hold of the real information, whether it's an infrastructure company or any company. Most of the time, your real books of account never come to light. Other transaction, you don't see the vouchers, the transaction trail. So many things are missing, and that also partly because of 29A. Because and PFUA transaction, of course, the promoter knows that in case he provides all that information to the RP, he is open to all these investigations. So his forensic audit will be sure and he will be behind. So he will try to hide the information. But these still have value. What we are struggling is how to find that value and how to find a market for that. So basically, market looks at 2-3 things. One is that identification of certain asset, which I said unrealized debtor is one class. Loans and advances, security deposit made by the company, another class of assets. Then you have contingent claims, arbitration claims, arbitration awards. So these 6-7 type of assets, which depend on each company, have different kind of assets. And each has a different market. So if RP is trying to sell all these assets to one company, there is no market as such. Again, there is a level of the market. Like if I talk about, say, some infrastructure company or construction company, I have been talking to Bad Bank regarding some large infrastructure assets. So they sought my advice, what can be done about these claims. I found that market has a certain threshold. There are investors in this market, foreign funds, which we call them third-party funds. They are looking at these assets, but there are certain dampeners, which again is our system, litigation system, which is very slow. So you cannot put a timeline on the stage of recovery, when they will recover, how much they will recover. Law is not very clear, although I think Pooja ji will clarify that legally they are recoverable. But the timelines, the valuation, all these things which market wants some visibility is not there. So coming back to your question, sir, so first thing as RP is what we should do is to identify, take maximum information, like for an arbitration award or claim. Unless you have the deep information regarding the vouchers raised, bills raised on the company, supporting documents, whatever claims you may file, that will be rejected by the arbitrator. So you need the support of the promoter. So that is what my advice is most of the time. In case of arbitration claims, always keep the promoter on your right side. That will be a big help in recovery. Part one. Second thing, you have to hire some valuers to value these assets. And these valuers will not be your registered valuers. They have no, I think, training or no qualification to value these kind of assets. These assets will be valued either by law firms, good lawyers, who can tell you what is the actual winnability of the case, what may be the underlying, and some expert who has actually worked in the field of arbitration and maybe worked in with particular agencies like NHAI. Somebody has worked with NHAI, he will know what is their mindset, how they calculate the award. So these kind of things, very, very niche area of valuation, which of course will develop over time when the market develops. But valuation is big challenge here. And as Madam rightly said, the court will always challenge your valuation. Whenever you go to the court for adjudication, like I remember that DHFL case where it was given to Piramals and all these 40,000 or 38,000 crore of contingent assets were given at ₹1. And that plan was stalled just because of that. And actually I also protested. But as an ex-banker, I felt that there's a lot of value in this. Somehow the court put a foot down, and then the bankers had to revisit that. And I think some negotiation went on and some value was put on that. And actually I tell you, in reality, Piramal has been able to extract a lot of value out of that. That is the information. So these have value. First is you have to see whether there is an underlying case. So three things the investor will look at. You can say this is a claim, but he will come in and look at whether actually this claim is implementable. There is a jurisdiction, there is a limitation, there are all legal requirements are available. Then he will look at, okay, what kind of valuation, he will do his own valuation. And when the two valuation match, then only deal will happen. Third thing, I would like to have a timeline, because he is not here to, like Indian litigation, sit for 10 years, wait for the return. No. All these third-party funders, they have timelines. And maximum timeline may be 2 to 3 years. So, and fourth thing, I would say that they are not exactly looking for entire assignment. They are not looking to buy assets. So as liquidator, they may help you to take care of your expenses, which you find difficult to get money to litigate. So he will come in and provide you funding. But he will not be readily available for buying that asset. That's not their domain area, not their requirement. So what they can do is bring another funder who may be interested in buying that asset, that risk asset. So there are two kind of things. One will be funding the litigation, another one will be buying the asset. There can be some agreement.
Yeah, so currently we are on identifying what is NRRA and what are the, how to identify that and taking the. So Maya, based on your practical experience, again coming to you, in your cases, how you identified and what kind of assets, briefly it has been covered, but anything more, you please elaborate, for the benefit of the participants, how you identify those assets and ensured that, there is no recovery possible, whether any valuation was carried out, and then approval by stakeholder consultation committee. What are the issues which you faced? I think you can share your practical experience with the participants.
So for any assignment of application or any contingent assets as NRRA, you must analyze what are the available options that you have. So first of all, in my cases, I first of all consult with the stakeholder consultation committee that these are the assets that will take lots of time to realize, and possibility is either 1%, 20% or 30%. So based on the decision of the stakeholder consultation committee, a certain sort of value could be determined. If the SEC says that we don't find any value in these assets if you sold it in the market. So in the law there has been provided certain provisions wherein the NRRA could be assigned. So first of all, you must, step one is you need to consult with the SEC that what value as per them that asset could fetch. If they say that this much value, say X amount can be fetched by assigning these assets. So based on the available records and other things, if I found that this value could be assigned for such an RRA, then first of all, I prefer to offer to the stakeholders themselves that if you think that this value could be taken if we sold in the market, first of all, I offer to you what the value you will give us so that I could conclude this assignment as prescribed under the regulation that you need to conclude within a year, right? So if the SEC says that no, we don't want to take these assets because already we have lost lots of money in the CD and we don't want to invest more than amount in it, and since the nature of this NRRA is contingent and recovery chances are less as compared to the time that it may take for getting the litigation part. So you publish it in the newspaper. So as under the regulation, we need to assign those assets through public auction. So in my case, if I know there is no value, so first of all, I just invite the public that this is the assets, and whosoever have any interest in taking up of these assets, submit your bid value. When we received any bid value for certain assets, of course, whosoever has interest will contact the liquidator and submit the bid based on the available documents after submission of confidential undertaking. So whatever the bid value that the prospective assignee will share, then again that matter need to be placed before the SEC that we have received these bids for these transactions. So now decide on these values that whether you are comfortable if we assign these assets. So because the stakeholders have a prerogative to decide that what value that NRRA could fetch. If they agree, then only the assignment date need to be executed. So for that, the provisions are very well mentioned in the law itself that while assignment of any NRRA, you need to follow certain procedure, and one of the important part in it that the assignee must be 29A compliant. So when you find that you have done the complete procedure, then only the assignment deed is executed.
So, so what is the stakeholders consultation committee? I found one of the orders by NCLT Space Metrics, wherein the liquidator has approached the adjudicating authority for taking the approval before conducting the process itself. So I think it's more of a to get, so that there is no problem crop up later on, essentially. Even though there is no requirement that once a stakeholder committee has approved an RRA. But I think in this particular case, liquidator or stakeholder consultation committee was trying to be on my part, and they took approval of the adjudicative authority.
Sir, in my matters, when I assigned these assets as NRRA, by that time regulation 37A was introduced. So if all the procedural part for assigning NRRA is provided under the regulation itself, coupled with the IBBA discussion paper, so I don't think that there is required prior approval from the NCLT. And I did assigned NRRA in 3 of my liquidation matters, wherein only one case it was rejected by the Honorable NCLT, but in other 2 matters that was approved.
Yeah, so that is why we call it an emerging area and the evolving jurisprudence around it. Mr. Sanjeev, coming back to you again, as a stakeholder, okay, how do you ensure that these assets are not left with any value? And as a banker, when you approve, because SCC approval is taken, that, how do you ensure that at this stage or, NRRA be identified and assigned, you see any checks and balances before this is approved?
I think one challenge I see is the valuation itself. In these assets, whatever value somebody put it at, as Madam rightly said, nobody knows whether it will be crystallized or it will go bust. Like zero money will be crystallized or 20 rupees or 100 rupees. So that is the biggest challenge in the sale of these assets. And ultimately, as a banker, if I sell it for say 10 rupees and tomorrow the party who has bought it recovers 200 rupees, so that is a setback for me. I have not really valued it properly. So alternate way which comes to my mind is that you assign with some recompense clause. Okay, I will be sharing the profits also. Okay, I assign at a certain token value, but let us create some arrangement, maybe a escrow arrangement or whatever arrangement, through which in future recoveries are shared in a particular ratio.
Agreed, sir. In two of my assignment, wherein I sold the assets on recompensate facility, so 40-60 ratio, 50-50 ratio, that was approved by the Honorable NCLT.
Yeah. So that is, I think, better way of doing it. And then you have the advantage of two things. Okay, now when you put a ratio, so that party will also share his valuation with you. So you have two valuations. When you negotiate with the counterparty, okay, what ratio we share, so he will show you his valuation, you will show him his valuation, then you come to a deal, okay, let us share in this ratio. So that is a better thing, then you recover better and you also reduce his uncertainty also. And upfront money is also kept at a low threshold. Because for these funders, he is going into a very, very uncertain area. He is taking very high level of risk. So to reduce his risk also, you give him offer him a token amount. Okay, I will pay you some token money and then we'll share the spoils. That way I think it's a better way of.
This also in accordance with the compliance of the law that you could not assign any NRRA at zero value. You must assign NRRA at certain value which market could fetch. As sir rightly said that you must mention a nominal value in case you have any situation wherein you have certain thing that these assets might earn something, say 50% of the value that you are assigning, say through transaction audit report or the depend upon the application that the company could be get this much of value, but due to uncertainty of litigation and the recovery part in contingency, so that ratio could be decided among the assignee and that proposal must be approved by the SCC.
Second thing that comes to my mind is that whenever you want to, like that is the problem with most of the CRP cases, we don't really get the real value. Why? Because hardly one plan comes. So you are not the choosers. You have one plan, whatever he offers, and generally we have seen where one or two plans are there, they are either close to liquidation value or below liquidation value. So if you really want to fetch a good price for these assets, create a market, attract at least 3, 4, 5 parties, let them bid, then you really have a market here. See, there is no Crawford market here in IBC. You have to create that Crawford market. So that is my appeal to everyone. Okay, you go out, reach out to the market, reach out to people, highlight these assets, their value inherent, and then you bring 4 or 5 suitors who will then quote and then you get the better price. And as a banker, you said that what is your thinking as a banker? I would say bankers are not really fit to claim good recovery here. So what I suggest is, let the bankers sell these assets to ARCs. They are better suited, better placed to negotiate, and they will aggregate this asset like one arbitration matter is there. 5 or 10 banks are there. So now this buyer has to negotiate with 10 banks for same arbitration claim. Why not sell that claim to a ARC and let that ARC deal with that person? So he will be able to fetch a much better price. So as a banker, that's my opinion. Thank you.
Pooja, I will come to you. I'm just setting the context and getting the practical experiences, which. So Maya, when you have had this auction on this platform, what kind of investors, evinced interest?
Sir, generally those, there is no such market is developed, but since this judgment has come, so definitely there is a shutdown in such type of transfer cases, but there is required to be developed the market wherein such type of assets could be sold, as the sir has rightly said, that as a banker, they would prefer to sell these assets through ARC. So no questions are being asked through the banks that why they have sold 1% or 5% of the assets to the ARC at that value. But in the liquidation, if you have not taken the proper steps, then you definitely would be in trouble.
So now we have understood the context and how NRRA journey has played out and what kind of challenges are being faced. Still, we have far to travel to achieve the objectives which were sought by introduction of NRRA. So Pooja, I would seek your views on essentially how to streamline identification and assignment of NRRAs. That is the first part. That how the risk can be mitigated for both liquidator as well as stakeholder committee, and also to make it attractive for the investors. And second, so once you address that part, and the what kind of investors who would be willing to participate in such kind of assets.
Very good afternoon to everyone. I think before we get into the NRRA and how exactly it can be assigned, I think I want to make one distinction between, in fact, what Mr. Pandey also mentioned. There is a distinction between funding, litigation funding, and an assignment of an NRRA. When we talk about a litigation funding simpliciter, it's basically an investor putting in money, giving the money to either the RP or the liquidator, because it need not be limited to liquidation, the litigation funding. You will have cases, a non-readily realizable assets even in a resolution scenario. And there are investors in the market who may be willing to give money to the resolution professional or liquidator for purposes of realization of those assets in exchange for some part of the recovery. And in India, it's absolutely legal to do that. It's just that, like you said, the market is not really developed, and there are various reasons for that. One of the primary reasons is uncertainty as far as litigation is concerned. So a lot of these assets are subject to litigation. There is a lot of delays. We have first appeals, second appeals, review, and now even curative for that matter. So nobody really knows when exactly these assets will be realized. So the funding itself becomes a problem as far as investors are concerned. Now coming to the NRRAs is basically an assignment of a non-readily assignable assets. Even before 37A, and I'm leaving aside avoidance transactions for a second, even without 37A, there was no restriction under law in actually assigning these type of assets, because even under Companies Act for that matter, even under IBC, an actionable claim is, you can assign, a liquidator can assign an actionable claim. He can either pursue an actionable claim or he can assign an actionable claim. To pursue a claim, he needs money, for which he will need litigation funding in case the company doesn't have money, or he can assign the claim or the actionable claim or the asset, whatever right he has on the assets, after taking consultation from the stakeholder consultation committee. So there was no restriction even before introduction of 37A. What 37A has done is it has streamlined the process a little, has introduced the element of transparency, which typically you would achieve by mechanism of public auction. If let's say there is a and I'll take a very simple example of receivables. I'll come to avoidance transactions in a second, like I said. But let's assume for a second you have a receivable from NHAI. There is an ongoing arbitration which is going on with NHAI, and there are certain claims which are there with NHAI, against NHAI, which have been filed. The liquidator doesn't have the money to really pursue those arbitrations because arbitrations are expensive and they do require money. And if he doesn't have that money to pursue the arbitrations, the easiest thing would be to actually assign those claims against NHAI by following a transparent process. So as far as the protection of the liquidator is concerned, I think there are two things which I would want to highlight. One is the transparency, which is absolutely essential. There has to be a transparent process, a market-driven process, which can be achieved through an auction process, for instance. And the second, what Mr. Pandey also rightly mentioned, is the valuation, which is the trickiest part really when you're valuing these claims. Because these claims could be zero, or these claims could be thousands and thousands of crores. Nobody really knows. We've all seen the recent DMRC example, right? It went right up till Supreme Court, review dismissed, you have curative. There is no certainty as far as recoverability is concerned. So when it comes to market and when it comes to investors who want to buy these assets, the lack of certainty is the biggest hindrance for anyone. So how do you value this? From a liquidator's perspective, what is desirable is to actually take advice of legal counsels and experts as far as recoverability is concerned. And being a lawyer, I can tell you there is no way you can 100% certify that something is recoverable or not. That's just the way things are in India. That's just how the litigation works. But you can give some assessment based on past precedents. Yes, the likelihood of recovery in this arbitration case is X versus Y. And everyone needs to put their mind to it and say that, yes, basis this opinion, expert opinion that we've got, be it an expert opinion from an expert in the field, you have various agencies, the likes of FTI and even a lot of accountancy firms who do provide expert services in valuing these type of claims. So you take help of those agencies, you take help of lawyers, and with the stakeholder consultation committee, come to a view as to what could potentially be the reserve price for this. Because like, Maya rightly said, and even Sir said, if you give it to a registered value, it's going to be zero. Nothing is going to come out of it. You have to come out with some reasonable basis for putting a number to it. And that's the best you can really do as a liquidator. There's nothing more you can do. And the second aspect I want to touch here is on the avoidance transactions. Now, in my personal view, when it comes to office holder claims, these are claims which are arising purely out of the code. For instance, a claim of fraud against the promoter. Now, is it assignable? If you actually look at Transfer of Property Act, a mere right to sue is not assignable. An asset is assignable. So if you have an asset which is, let's say, subject to a security interest, I may have a pledge, I may have shares in my subsidiary company which are subject to a pledge, and I may have challenged that pledge as a preferential transaction, but there is still an asset for me to assign. I can assign that. But a claim for a fraud against the promoters, I'm not sure whether that's really assignable without an amendment to the code. And I think that's where things get very tricky, and the issues of valuation come into picture, and also issues of misuse come into picture. So if I have, let's say, a claim of fraud against the promoter, who is going to buy this claim? It's probably going to be promoter in some avatar using, your trying to buy this claim so that it can eventually settle that matter or somehow, derail the matter. So I think that's where things get trickier, and we need more clarity on that.
So, Pooja, you raised a very important issue that, a right to sue cannot be assigned. Same way as I understand in contract and that, obligations cannot be assigned. Okay. So how, there are multiple challenges, in that respect, and also arbitration. If it is without the consent of the other party, then again there is an issue in assigning. So, so how do you see that, these aspects are taken care of, and we see that healthy market is developed, and as Mr. Pandey also said, NARC is also looking, and we have large EPC companies, which have thousands of crores of arbitration claims, the claims or other liabilities sitting on their book. So, what do you suggest these issues be streamlined, so that we first of all, we tackle these assets, and secondly, a healthy market develops for them.
See, there is no one size fit all that you will find here, because every asset, every claim is going to be different. My right to a receivable, my claim against my debtor, I can assign, and I don't need a counterparty consent. So the minute I assign it, all litigations and arbitrations connected with it also get assigned, and the assignee can pursue that. That's one asset class. You may have some other asset classes where there may be a requirement to take counterparty consent. That, of course, you will need a counterparty consent, otherwise it will be challenged as being against the law. And end of the day, we have to realize that an assignment is nothing but a contract. So the principles of the Contract Act will come into play in these cases as well. So if my contract is unconscionable, if my contract of assignment is against the underlying contract itself, then obviously all of these are subject to challenges. Now the best way to really develop the market is for the lawmakers to give it a push. So I'll give a very simple example, and Mr. Gupta, I'm sure you would agree with it. The reason why we had such a healthy IBC market, which got developed in the first 2 to 3 years, is because there was a push from the RBI to push some of the biggest cases into insolvency, which actually resulted in a lot of precedents being set up, with a lot of work which was done on account of these cases. So sometimes you need a push from the government, from the regulator, to develop these markets. So the more you streamline, the more clarity you provide, the more certainty you give to the funders, it'll become easier. So again, another example I can think of is this: why do we have so many cases sometimes, especially in cases of avoidance, for instance, so many objections being filed? Because we don't have a system of avoiding costs. We don't have a system where the court will award costs against the party who's doing frivolous litigation. So there are some very simple measures which can be taken by introducing some of the concepts, by streamlining some of the issues, by giving certain clarifications, which can give a push to this market. And some of them are fairly, fairly easy things to do. But yes, it will require some regulatory and governmental interference.
So one important point which has been made by Pooja is that one should carry out a critical examination of all the NRAs, that what kind of asset is it, and and if it is put in NRA basket, what kind of legal implications it will have, so that each claim, I think, will have to be examined from the legal lens. And
yeah, and in some cases you may find that assignment is not possible for whatever reasons. There may be restriction in the underlying contract to assign the right, or whatever it may be. If it's not possible, and you know that the claim is actually valuable, you would explore a litigation funding mechanism as opposed to an NRRA. So assigning, for instance, setting up some sort of a trust, getting an investor who can actually fund the litigation, and pursuing that litigation, so that without assigning the claim itself, the liquidator is able to pursue it in its own name, in his or her own name. But the funding is being provided by the investors with some, right to share the profits. And again, the right to share profits again is going to be a question mark in terms of how much profits you can share. Because under Indian law, like I said, things can be tested from the prism of Contract Act. There have been cases where, for instance, where 3/4 of the profits was being shared with the investor, the court said it's actually extortionate. So those are also some of the issues that will have to be looked at.
I'll just add to that. I think in the liquidation regulation, there is a provision of transfer of assets to the creditors.
The creditors, yes.
So here you can just transfer to creditors, create a escrow arrangement, and let them recover.
Yeah, there can be many creative
Many
ways of
creative,
actually dealing with an issue, but it has to be done asset by asset.
that's important. That is another way of achieving the objective of essentially liquidating the assets and and closing the liquidation process. So I was. So around litigation funding. So we discussed on NRRA. So what is the current regime, in India on litigation funding, and whether these investors have to be 29A compliant, and what kind of investors are these?
So, litigation funding, surprisingly, in India, unlike the other common law jurisdictions, we never really had an issue with litigation funding. The issues against litigation funding really come from surety and maintenance, rules against surety and maintenance, and India actually has never had those rules. So from the very beginning, India is one of the few jurisdictions which actually has not regulated or found litigation funding to be an issue. So as far as the legal regime is concerned, it's fine, subject to, of course, 2 caveats. As lawyers, we can't participate in litigation funding. So we can't, do the case, let's say, on a success fee basis. So that's one thing which is a restriction, and also I feel sometimes an impediment, because in a lot of other jurisdictions, the lawyers themselves can take the risk and do the case and take benefit of, whatever the recoveries is, unlike India. And the second is, like I said, the contract itself, the litigation funding contract should be in compliance with Contract Act. It should not be against the public policy. It should not be, extortionate. It should not be unconscionable. So that's as far as the law is concerned. Investors, there has been in the last few years lot of interest by a lot of investors in litigation funding in India. There are various international firms, the likes of Burford Capital, you have Omnibridge, you have many other, Fulcrum Capital, all of them very, very actively looking at India from an investment perspective. But like I said, the uncertainty of litigation, I think, is one of the key things which has actually prevented development of a market, especially in terms of delays and the lack of, the costs which can be avoided. I think these two are the major impediments in developing the market for these investors. 29A, I think it's a very interesting question. As far as the assignment is concerned, we are very clear that 29A will come into picture. So an outright assignment of an NRRA or a claim would be a problem. But funding, a simple funding to the company, would it be hit by 29A? Possibly not. It's like interim finance. Litigation funding is essentially an interim finance which is being given to the company for pursuing the litigation, subject to, it's just that instead of getting an interest like a bank would charge, you're getting a right to recover. But having said that, I would assume that if a promoter is trying to do a litigation funding into the company, it'll have to be tested from the prism of public policy. Why is he funding it? Is it because he wants a share of the profits? I think it'll need to be tested from that perspective. But if you look at just law, there is no restriction in a promoter actually providing an interim finance.
I'll add to that. Basically, the litigation funder, as Madam rightly said, he's bringing in equity, not the debt, because he's not interested in interest. So he's coming in as an equity partner, bringing in some interim finance. But his return is multiple times of that finance. So he has because of high risk, his expectation of return is also very high.
Maya, so with the assignment of NRRAs, were you able to achieve the objective and file for dissolution, or still the issues left? And what kind of documentation you had to complete by way of in the process of assignment?
So as I have explained earlier also, so before assignment, you need to take proper approval from the SCC itself. And when SCC is agreed that certain value is being fetched for a contingent assets, because if there is a certain value, you definitely sell those assets around that value itself. But when you are not sure that what the value that certain assets could be fetched, say contingent assets, that assets, as ma'am has rightly said, that right to sue, that cannot be assigned. But if there is certain assets which can be recovered from under the avoidance transaction or some recovery from the debtors, that can be assigned to a defined value, and that value could be ascertained with the consultation of the SCC as well as the lawyers and the third party who can assess that this value could be fetched. Once you finalize, so through a transparent process, you need to do the public auction, and the available bids, as again said, is a part of the transparent process wherein you could assign the debt. So once this procedure is done, there is required to execute an important document is called assignment deed. Once you have properly execute the assignment deed, by that deed, as a liquidator, you must submit the progress report and the form match and all those documents that are required to dissolve the company once you have assigned. Further, if there is certain litigation is pending that you are assigning through assignment deed, so liquidation, dissolution of that company can't possible until the assignee come into the shoe of the liquidator. So once that impediment application is allowed, the liquidator is allowed to pursue the dissolution application. Otherwise, these applications for dissolution as well as the impediment applications are filed simultaneously before the adjudicating authority.
Essentially, what I feel, after listening to the discussion, that a liquidator should start identifying NRRA and evaluation done around that, including, legal views from day one rather than after selling all the tangible and intangible assets. That will essentially give him or her more time to achieve a successful plan for that. Pooja, now on this assignment part, what are the registration and stamp duty implications, as stamp duty is a state subject, and generally now it is going to be on the value of the transaction, and the stamp duty, will it be on the consideration given for NRRA or probable value of underlying assets? Like, underlying asset, if it is some real estate, so it will be the value of the real estate, underlying real estate entire will be considered, or value of the consideration.
Well, I always say there's one thing about practice and there's one thing about how it's implemented.
Right.
You ask a state stamp authority what will be charged at, they'll say everything. So, but practically, how are people stamping it? They're not stamping it at full value. And you rightly said it's really a state subject and depends on what asset is being assigned. Going back to the example that you gave, for instance, I have a property, for instance, which is subject to a suit which is going on. I could say that it is an NRRA because there is a suit which is going on the title, but I have conveyed the property itself on an as-is where-is basis, subject to whatever the limitations are going to be. I will stamp it as the way I would convey the property itself. That's how I would typically do it. And yes, the risk of the title being actually reversed subsequently is on the buyer because it's done on an as-is where-is basis. Even that is an NRRA because you could say that it's not readily realizable because of all of these issues which are there. Or I could have an underlying receivable which I am assigning by way of the assignment deed, in which case I will look at the value of the receivable itself, very much like an asset reconstruction company, for instance, if it's buying a loan. I mean, there is an exemption, of course, for the ARCs, but if you are assigning loans, you would stamp it at the value of the loan, unless of course there are exemptions in various states on that. So you would do it on that basis. There may be some assignments which actually you may not even need to, you may need to pay a nominal stamp duty depending on what the value of the asset is. A lot of time the movable assets are assigned through delivery, for instance, and you could have a recordal to say that all the clogs or all the issues are yours, of the buyer, but I am transferring this movable asset, like for instance, shares. I have shares which are subject to a pledge. The pledge is subject to a preference transaction in the court. I may enter into a general assignment deed or a general agreement to say whatever rights I have in these shares, I am assigning to you. That may not actually be stamped at full value. That may be a nominal value of stamp duty. So it depends on each asset, what is the underlying asset that you are assigning, and what is the nature. Is it a movable asset? Is it an immovable asset? Is the transfer happening through delivery? Is the transfer happening by way of registration? So those are some of the issues that you'll have to look at while determining stamp duty, and it's not going to be an easy analysis.
Yeah, that's right. You know, there are certain states which are stamp duty friendly, and there are certain states where the stamp duty itself will be very high. I remember I had faced an instance, you know, where some assignment was filed, some operational creditor and some receivables of a few thousand crores were assigned, and it was registered. It was registered in not registered, but it was Delhi. Transactions jurisdiction was in Delhi, and when he asked them to register, you know, the stamp duty was so high, they simply could not register. So I think these aspects also need to be keep in mind while you know, considering assignment, while evaluating. So so that is something for liquidity. So how can we now coming to the question? You know, we have gone into the issues or challenging which one is facing. So what kind of you know, any relaxation or further knowledge spreading about it or through a regulator, we can streamline it? You think there are one or two aspects, Pooja, which can really help this market to grow and have the investors attracted to this large pool of claims?
You know, like, I think that a lot of the market it's going to be linked with how much efficiency we can bring in the legal system, especially if the claims are subject to litigation. In arbitration, it becomes slightly easier because arbitrations, you still, I mean, I guess after the DMRC, we don't know, because anything you know, you can upset it at any stage. But still, there is more certainty when you have existing arbitration claims versus cases where cases will need to be filed and you don't have certainty as far as the recoverability is concerned. But some of the things which can help in growth of the market is, I think the cost, making it imposition of some kind of costs would be one thing. I personally think even amendments to Bar Council rules to allow lawyers to charge on a success fee basis, for instance, could actually help in developing the market. Some clarity around the right to sue, and I think that actually needs an amendment, because there is a provision in the Transfer of Property Act which prevents a mere right to sue. So either there is an amendment in the code or some sort of a clarification which is brought in to say that even office holder claims can be assigned. And there I think there is a larger public policy element also, because you're assigning claims such as claims for fraud, you know, and these are prone to misuse. If I am, for instance, someone who wants to, you know, go after the promoter, let's say I have a personal vendetta against the promoter, I could potentially buy these claims and pursue against the promoter. So some sort of, obviously the safeguards will need to be built. But yes, some regulatory clarifications will be helpful. Some guidance is also going to be helpful, because I think a lot of times what happens is the liquidators and the RPs find their hands tied because they don't want to take the risk. And they don't want to take the risk because they feel that if there is some mistake, let's say in valuation or assessment, the regulator will come after them, the NCLT will come after them. So strengthening their hands is also going to, I think help the market.
So, thanks a lot. We will, if there is any question, one or two questions we can take. Yes, yes, sir.
Thank you, Madam, for an insightful session and covering the comprehensive. I don't have a question. I have just an input. I think there was a discussion about the innovative way. There is one order in respect of Lanco Infratech, I think, where all these what you call contingent claims are sold as a going concern. I mean, that is just the input I wanted to share. Fantastic session. Thank you very much.
Thank you.
On behalf of Ahmedabad branch, I would like to thank all the panelists and the moderator, sir, Mr. Satish Gupta, for coming here and sharing their immense knowledge on the subject. And now a request to our members, Anjali Choksi ji, to have a memory with the team.